If you're a builder in Queensland and an owner is demanding site changes without signing the variation paperwork, you need to understand 4 things before you pick up a tool. First, proceeding with owner-requested changes without written approval may severely limit your recovery rights under Schedule 1B of the Queensland Building and Construction Commission Act 1991. That means if you do the work on a handshake, you may not be able to invoice for it. The writing requirement isn't optional. It's a statutory barrier to getting paid. Second, if a payment dispute follows and you fail to issue a payment schedule within 15 business days, you can be rendered liable to pay the full claimed amount, stripping your ability to set off defect costs. That deadline runs from the moment the payment claim is served, and missing it can hand the other side a 6-figure adjudication award, even if the amount claimed was inflated. Third, standard form extension of time and variation clauses may be rendered void, and since November 2023 may attract significant civil penalties under the Australian Consumer Law if they grant the builder unilateral power that is not reasonably necessary to protect the builder's legitimate interests. This applies even if you're using a template from a major industry body. If the clause gives you a right the owner doesn't have, and that right is not reasonably necessary to protect your legitimate interests, a tribunal can strike it down entirely. And fourth, quantum meruit, or restitutionary claims for unwritten variations, remain legally complex. They are treated by Queensland tribunals as contextual rather than automatic, and rely heavily on demonstrating that the owner genuinely benefited from the work. This is not a reliable fallback strategy. The bottom line, halt the work, get the variation signed, and protect your right to be paid. If you're already in a dispute over unwritten variations, get independent legal advice specific to your circumstances early.